What do you do when a client ghosts you on payment? You delivered the service, you upheld your end of the deal, but now, crickets. No check in the mail, no return calls, just silence. If you're a business owner in Florida, this isn't just frustrating, it's dangerous. Because letting unpaid invoices slide sends a message: you don't enforce your value. I'm Santiago Cueto, a board-certified international business lawyer and best-selling author right here in Miami. Over the years, I've helped countless Florida businesses recover millions in unpaid fees without burning bridges or blowing budgets. And today, I'm going to walk you through the exact steps to take when a client stops paying, legally, tactically, and effectively. Step 1, step into action, not emotion. The biggest mistake I see, business owners waiting too long. They take it personally or avoid the awkward follow-up. That delay weakens your leverage. The moment payment is overdue, you must shift from a casual follow-up to a documented strategic response. Send a formal demand letter on your company's letterhead or preferably through an attorney. In Florida, timing is everything. You're building a paper trail that matters in court, or better yet, makes court unnecessary. Step 2, review your contract first. Before you even send the letter, go back to the contract. Does it include a clear payment deadline, interest or late fees, a collection cost clause? If it does, great, you've got leverage. If it doesn't, that's your first legal lesson. Always prepare for enforcement before problems arise. Still, even with a weak contract, Florida law may entitle you to recover under quantum merit or unjust enrichment. You performed the work and they got the benefit. Here's step 3. Try to resolve before suing. Litigation should be your last move, not your first. Start by sending a pre-suit demand outlining the amounts owed, the timeline to pay, and the consequences of ignoring it. Many Florida businesses also turn to mediation, faster and cheaper than court. Sometimes just showing that you're serious pushes the client to settle. And remember, anything you put in writing should be calm, professional, and factual. Avoid threats. Courts don't look kindly on that. Here's step 4. File a claim strategically. Still no response? Now it's time to file a small claims lawsuit if under $8,000 or a civil action for larger amounts. In some cases, if your agreement allows it, you can also recover attorney's fees, so don't eat the cost of going to court. Bonus tip. If the client is a business, consider naming both the company and the individual behind the contract, especially if there's any evidence of fraud or a personal guarantee. Also, explore prejudgment risks of garnishment or attachments if you fear they're moving money or assets. In part 5, secure the judgment, then enforce it. Winning in court is only half the battle. Next, you'll need to enforce the judgment. In Florida, you can garnish their bank accounts, lien their property, and seize assets, but you must act quickly and strategically. Florida's debtor-friendly laws offer protections, but there are ways around it, especially if the client is a business entity with assets you can trace. And if they file for bankruptcy, that's a whole different game, but with proper documentation and legal support, you may still have options. Here's the truth. Chasing unpaid invoices is just part of doing business, but how you respond defines your company's strength. Don't let clients treat payments like an option. Build strong contracts, enforce them with consistency, and when in doubt, call in legal reinforcement early. I'm Santiago Cueto. If you found this helpful, like, subscribe, and drop a comment below, specifically if you've ever dealt with a client who stopped paying. Let's make sure Florida businesses get paid what they're owed. See you in the next one.